I have an objection to a proposed order, but I do not have a proposed order. Where are we at, counsel?
It's
Oh.
there's
I'm sorry. Go ahead, Mr. Rolla. You want to go
there's
first?
the court should have a copy of an order. We have a copy in our file, but the original's already been provided.
That order basically sets child support, leaves, does not address legal or physical custody or parenting time. So we're asking for a hearing on all of those things. We're not contesting paternity.
Judge,
So
actually,
you refer it to a referee for a referee hearing, Your Honor.
Judge,
Mr. Rowe.
with all due respect, the order specifically addresses custody, legal custody, and as was explained to the parties, as far physical custody being with the plaintiff, legal custody as required by statutes with both parties. It specifically addresses that in the order.
There's no findings whatsoever on the 13 factors, and there's nothing that sets a parenting time schedule. The child support amount is based on 0 overnights. I think my client has the right to a referee hearing on those matters.
And he does after this order is entered.
That has been, Ms. Kerr, that has been the typical procedure used by this court. There is not a precedential value in the order that Mr. Rolla submits as far as custody, parenting time, and child support. It's simply an order that allows the case to move forward. And if you wish to ask for a friend of the court hearing, you're certainly entitled to have all of that. And it would be without precedential value. It's simply an order that gets the case moving in this circuit.
Well, the child support amount is not calculated correctly. I have no basis whatsoever to, I mean, I have no information other than what's in the recommendations with regard to income. And again, it calculates on 0 overnights. It's not, I just don't think it's fair to my client to, and I know that it could be possibly be retroactively modified, but without objecting to it, it can't be retroactively modified. And I don't want to have an argument that I need to show a change in circumstance or proper cause in order to modify the order.
Nope. None of those things would happen in this case because of the court's typical procedures allowed. I can certainly treat your objection to the proposed order as a motion for child support. We could submit it to the friend of the court. You could, and then you could contact the court, set up a friend of the court referee hearing on custody and parenting time. So I don't want to create extra work for you either. However, typically the court does sign the proposed orders from Mr. Rolla's office, and then all of those matters are taken care of at the friend of the court level without precedential value. Nobody's taking anything away or saying that you don't have the right to make those claims. We just do that in a slightly different manner than what you're asking us to do. So any problem with simply submitting those matters to the friend of the court, Ms. Kerr?
I'm a little confused about the USO. Are you saying that you would reserve signing the USO but sign the other order? Or
well, part of my problem is I don't have it in front of me, so I don't know exactly what Mr. Rolla is asking for, and I don't know why it's not in front of me, but I just know it's not in the court file.
it's a significant amount of money, Judge. It's like almost $2,000 a month in child support. Well,
you have objected to that. I won't sign that. Then if you've objected to it, we'll refer it to the friend of the court. But if there's a typical other order that I've seen 100 times from Mr. Rolla on these matters, I will sign that. Why don't we do this, Ms. Kerr? Why don't you follow up with an order from today's hearing that says that you are allowed to contest custody, parenting time, and object to child support, and that all of those matters would be referred to the friend of the court for a de novo, not a de novo, for an original hearing on all of those matters. I don't see any harm in that.
without having to show proper cause or change of circumstance.
Correct. You can put that language right in the order to protect your rights if you wish. Any objection to that, Mr. Rolla?
I do not. I just indicate for the benefit of the court. And I understand you don't have a copy of it with you. My apologies on that. I don't know. I know it's been filed with the court. Why you don't have it, I can't say. But there is language in there that the matter is referred to the friend of the court for those purposes. No, not in the,
All right.
It's not,
that as far as the child support, it was based on 0 overnights because our offices received no information to the contrary.
All right, I'm not throwing stones or poking holes in anybody's boat. All I'm saying is, the normal process is Mr. Rolls submits the order, I sign it, and it goes to the friend of the court if anybody wants to do that. Ms. Kerr, if you want to have a specific order that allows you to do that, please submit it to me. And if put whatever language in there you want to do to protect your right to have a proper hearing in front of the friend of the court without, in front of the referee, without all of those proper cause and substantial change of circumstances language. This you would be entitled to do that, I believe. But if you need that language in there to protect your client's rights, I'm happy to sign an order that has that in it.
And Judge, we have no objection to them doing that because as I agree with the court, she has that right anyway, or in this case, the respondent would have that right.
Mr. Rolla, would it be beneficial here for you and I to maybe talk and just submit a consent order if we could agree on some language and then we wouldn't have to have 2 orders?
Well, the one order is simply establishing paternity and referring the other matters to the friend of the court.
Okay,
If you
I don't
want to-
remember it that way.
If you want to send a proposed order to my office with other language in it, why don't you do that? I'll be happy to take a look at it.
I'll do that. That would be great. Thank you.
Not a problem.
All right.
Thank you, Your Honor.
I look forward to receiving consent order from both of you. All right. That's all for today then. Thank you.
All
Thank
right.
you, Judge.
This is a friend of the court petition regarding overpayment and credit and notice of a hearing. Mr. Brzezinski, could you inform the court of where we're at?
Yeah, just going to briefly outline the petition. There was a support order that entered on March 17th of 2020 for the defendant to be the payer of support. Entry of this order created an overpayment. As of the time of the petition and still as of today's date, the amount of the overpayment is $149. The friend of the court had sent multiple requests to address it. Plaintiff did not deny permission, so the friend of the court ultimately took an administrative action, reduced collections on the defendant's support account, and that was going to eventually eliminate the overpayment. But then on March 14th of this year, an order entered for the defendant to no longer be the payer of support. They became the payee of support, and the plaintiff became the payer of support. So we are no longer able to address the overpayment through a reduction in collections. So now we're asking the court to issue an order permitting friend of the court to take the money that the defendant overpaid the plaintiff and put it onto the plaintiff support account as an arrearage.
All right. Mr. Corby, did you understand what Mr. Brzezinski said to the judge, said to the court?
Yes, yep, that there was an overpayment somewhere, and I know I had to pay it back. That I guess I wasn't trying to be difficult and not turn the paperwork in, but I know I missed the first paperwork. I don't know what happened to it. I couldn't send it back, but the second one I remember, I just assumed that it said that if I didn't respond, they would just take the money back. So that's why I wasn't arguing it, and that's what I remember my caseworker called and asked me, and I told her that I wasn't arguing the fact that I was overpaid. I thought they were going to take it back in increments, and I didn't realize that I was supposed to respond by paper.
All right. They were in fact taking it back in increments while Ms. Sevner was doing the paying. But now that she is receiving child support from you, they can't take it back that way anymore because there's no payments for which to do that under. So their request is that we put this as an arrears, that is an amount owed by you, which you would be required to pay back. So what is your plan for doing so?
I guess I'd stick with the increments paying back slowly, I guess, or monthly.
How much do you want to do per month?
I guess just split it in half.
Make two payments out of it?
Sure.
So that'd be about $70 some each monthly payment added, and then it'd be done. Is that what you want to do?
Right. Yep.
All right.
Yes,
Mr.
sir.
Brzezinski, is there anything else that needs to be done today then?
No, we can make that happen.
All right. So Mr. Corby, the next before June's payment, right? Whenever you typically make that, you'd make the first half of payment. In July, you'd make the next half payment. Then that would be in addition to the amounts that you've been currently ordered to pay as support amounts.
Okay.
All right, the friend of the court will submit a proposed order to me for that. I'll sign it, and then we'll have the payments made shortly thereafter. All right, thank you very much. Ms. Sevener, any questions that you have?
No, I don't. Thank you.
All right, Mr. Corby, any questions that you have?
Nope, not at this time.
Mr. Brzezinski, is there anything else?
No, thank you.
All right, that will be the order of the court. Thank you all very much. I appreciate your time.
All right, thank you.
Thank you.